So, as I'm sure you know, this is under the auspices of the Historical Society of the New York Courts. Many of you, if not most of you, are members. If you're not a member, please feel free to join. We have great programs that we put on, and we also have a website that is of immeasurable value. So it's our job to protect and promote the legal history of the state. And we do that through programs of this kind. Our director, Marilyn Marcus, is here tonight, and other folks with whom we're associated. And several months ago, Marilyn and I were chatting with Craig Landy, and he was the one who pointed out that we are on the heels of the 200th anniversary of Gibbons against Ogden, and thought that this would make an ideal program because it's multifaceted. Not only is the case interesting because it originated in the New York courts, but because it deals with basically not only federalism and the growth of our nation and the importance of the John Marshall Court in federalizing our union as opposed to a fragmentary European Union, so to speak, but also because it laid the groundwork for jurisprudence of enormous importance, notably Commerce Clause litigation. And over the years, cases involving the Commerce Clause have occupied a central part in our jurisprudence, not only from breaking up the monopoly that was originally given to Livingston and Fulton and Ogden, but toward later interpretations of the Commerce Clause, which we're going to hear about more from the others. But just to remind you that a decade or so ago, or a little more than that, the United States Supreme Court struck down a series of congressional acts on the ground that the Congress has no power to legislate except as prescribed, notably arising out of the Necessary and Proper Clause through the Commerce Clause. And because the court felt that the Congress was out of line, they struck down congressional litigation. So here's the Commerce Clause back again. It will never disappear. It's part of our fabric. So without more, I want to introduce Craig Landy, who is a practicing attorney. He's a scholar. He's written articles that have appeared in New York History, Rhode Island History, and Judicial Notice. And he's taught at New York Law School as an adjunct professor for over 20 years. And he's the inspiration for tonight's program, Craig Landy.
Thank you, Judge, and thank you to Marilyn and all the members of her staff. Tonight would not have been possible without their devotion and their attention to detail. We're really lucky tonight to have a panel of experts that cover, as the judge said, a wide range of topics, from the history of steamboats to an individual instance of regulation by Congress to detailed description of Gibbons, the case. And at the end of the presentations, I will come back and attempt to give you a summary of 200 years of Supreme Court knowledge on the Commerce Clause. So let me first start by introducing Brian O'Connor to my right. Brian received his bachelor's and law degree from St. John's Law School, where he was on the Law Review and a publications editor. Upon graduating, Brian served as law clerk to the Honorable Matthew Jason, Senior Judge of the New York Court of Appeals. Then Brian joined the law firm of Wilkie, Farr, and Gallagher as an associate in the litigation department, where he specialized in complex commercial litigation. Brian then became a member of the firm in 1987 and its general counsel in 2017. Brian is retired now and lives on Eaton's Neck in Northport, which I hope he'll tie in with his comments when we hear from Brian. Brian is also the author of the book Death by Fire and Ice, the Steamboat Lexington Calamity, which I hope he'll also refer to in his comments. Judge Rosenblatt, who is no stranger to most of you, is of counsel to the law firm of McCabe and Mack, and he is a judicial fellow at New York University School of Law. Judge Rosenblatt served as an associate judge on the New York Court of Appeals, a justice of the appellate division. He was the New York State Chief Administrative Judge. He also served as a justice of the New York State Supreme Court, and also county court judge and district attorney for Dutchess County. Now, I don't think there are too many other courts that I can think of in New York that the judge has not served in his distinguished public service career. He earned his undergraduate degree from the University of Pennsylvania and his law degree from Harvard Law School. And he is the inaugural Albert M. Rosenblatt Legal History Scholar, and he's also President Emeritus of the Historical Society. Dr. Carla Lesh, to my left, is Collections Manager and Digital Archivist at the Hudson River Maritime Museum. Founded in 1979, the museum has grown to become a significant history museum in New York's Hudson River Valley. A professional staff of dedicated volunteers and a rare collection of archives of more than 1 million items may be found at this museum. Dr. Lesh earned her Bachelor of Arts degree from the University of Massachusetts at Amherst and her doctorate from the University at Albany. The Hudson River Maritime Museum was established by steamboat and tug pilot crew members, and consequently, a large percentage of its collections and archives are related to these historic operations. Won't you please join me in welcoming Dr. Carla Lesh.
Well, thank you for inviting Hudson River Maritime Museum to participate in this conference. This presentation is a joint effort, as is most of the work at the museum. While I am presenting, the content was written by Mark Peckham. Geographically, New York was more fortunate than many of its North American neighbors. It had an extensive and protected deep-water ocean harbor and a tidal river that extended well into an interior rich with natural resources and farmland. Tributaries of the Hudson River, most notably the Mohawk River, extended water transportation further inland to the Great Lakes through the use of smaller boats and portages. Using wind and tide, sailing vessels of varying tonnages and rigs efficiently carried freight and passengers up and down the Hudson River for almost 200 years. The river, in many ways, functioned as New York's Main Street, and its population was distributed in close proximity to its banks. Sail transportation served the colony and later the state of New York very well. So well, in fact, that it became a crucial military corridor and objective in the American Revolution. Nevertheless, there were limitations. Sailing against a tide was often useless. There were hours and days when the wind was weak or contrary, and there was shallow water below Albany that became a barrier to larger or more heavily laden boats, especially during periods of low rainfall. Finally, there was no travel those months when the river froze. Sloops and schooners of 100 tons on average made the 150-mile trip between Albany and New York in several days or a week, depending on wind, tide, and the need to take on or discharge freight and passengers at intervening landings. Still, these boats were a far more comfortable and efficient means of transportation than the use of the adjacent roads, which were slow to be developed and improved. Interest in the use of steam to propel boats long preceded its successful introduction on the Hudson River in 1807. During the 18th century, a series of inventors in Europe and America built models and prototypes. Many failed, including designs using pumps. Others showed promise, notably boats by John Fitch and John Stevens in the United States, and William Symington in Scotland a few years later in 1803. It is important to recognize that Robert Fulton did not invent the steamboat. He was, however, an unusually talented engineer, adept at combining and improving the best ideas of others, recruiting political power and capital, and systematically refining and scaling up concepts into reliable machines and highly profitable enterprises. Robert Fulton and Robert Livingston, U.S. Minister to France, met in Paris. Livingston was impressed with Fulton's engineering talents and ideas about steam navigation, and the two formed a partnership in 1802 to advance plans for a steamboat in New York. Livingston would provide additional cash for the venture and secure a monopoly from the New York legislature to protect the resulting steamboat from competition. Profits would be shared. Fulton built several experimental models. In 1803, he launched a 70-foot-long prototype in Paris that succeeded in steaming 3 miles an hour against a strong current and 6 miles an hour with the current. Fulton improved upon the design, purchased a Boulton and Watt engine in England, and returned to New York in 1806 to begin work on a new and full-scale boat. Livingston went to work with the legislature in Albany, successfully renewing an earlier monopoly. The new monopoly, granted in 1807, extended exclusive steaming rights for 30 years, provided that he and Fulton produced a steamboat that could operate 4 miles an hour against the tide. It also included penalties for boats operated by unlicensed competitors. The North River Steamboat, later to be popularized as the Claremont, made her first upriver run on August 17, 1807, and quickly proved profitable and popular. She made her first trip to Albany in 32 hours and returned to New York in 30 hours, opening a new and revolutionary era of reliable, scheduled boat service on the river. Challenges against this lucrative business began almost immediately. Some sailing boat masters attempted to sabotage the steamboat through collisions, forcing Fulton to build protective covers over the paddle wheels. Several would-be competitors copied Fulton's designs and challenged the monopoly. Fulton's patent was even delayed by an ambitious patent office superintendent. Nevertheless, the Fulton-Livingston partnership prospered, and new boats came off the ways and went into service. In 1818, the North River Steamboat Company earned profits of over $61,000 and dividends of $49,000, monumental amounts of money in a day when skilled laborers earned an average of $1 a day. The partnership obtained a similar 18-year monopoly in 1812 for the enormous territory of Louisiana that Livingston had helped purchase on behalf of the nation in 1803. Unlike the Hudson, two-way transportation up and down the swiftly flowing Mississippi and its tributaries was impossible without mechanical propulsion. As Fulton astutely recognized, the introduction of steam navigation in the West would be key to that region's economic development. In 1811, Fulton and Livingston built and operated the first steamboat west of the Appalachians, the paddle wheel steamer New Orleans. This boat demonstrated the ability to steam upstream against a significant current. By 1817, there were 12 steamboats on the western rivers. Livingston and Fulton both died in 1813 and 1815, respectively, before their joint steamboat monopoly was extinguished. Heirs of the partnership continued to earn profits and benefit from licenses as steamboats and ferries ushered in a new age of regular and reliable water transportation. The profitability of steamboats, however, inspired cutthroat efforts to circumvent or challenge the monopoly, with years of continuing litigation. In 1818, Thomas Gibbons launched the steamboat Bologna to challenge former partner Aaron Ogden's New Jersey ferry Atalanta, which operated in New York waters under a Fulton-Livingston franchise. Gibbons held a federal coasting license, which he claimed superseded any New York state restrictions. Gibbons hired local pilot Cornelius Vanderbilt, to operate the boat and to protect his interests. In 1820, Chancellor James Kent of New York's highest court issued an injunction ordering Gibbons to stop. We'll hear what Gibbons thought of that in the presentations that follow. Gibbons continued to do all that he could to ruin Ogden and his business. He sued repeatedly, touching off a cat and mouse game with process servers and enforcement officials that resulted in arrests and fines. Ogden's boat Olive Branch deliberately crashed into the Bellona in an attempt to disable her. There are also colorful but unverified anecdotes that Vanderbilt escaped arrests through the use of secret compartments, taking process servers hostage, and through the shocking use of a woman to pilot the Bellona into the dock, knowing the authorities would be reluctant to arrest her. Gibbons managed to have the crew of Ogden's Olive Branch arrested and briefly detained in New Jersey. By 1824, steam technology was well understood, and competitors raced to launch boats and to compete in lucrative passenger markets. On the Hudson River, a new and luxurious steamboat, Chief Justice Marshall, entered service in 1825 to compete with the Livingston-Fulton frontrunner James Kent. Dozens of new boats were built. Passenger rates declined precipitously in the rush to undercut competitors. The standard $7 fare between Albany and New York dropped to as low as half a dollar in 1837, and there were instances where passengers traveled free in order to put competitors out of business. Unabated competition also led to efforts to build faster and more luxurious boats. Average operating speeds increased from about 10 miles an hour in 1824 to over 20 miles an hour in 1860. Keen competition also encouraged racing, risk-taking, and complacent safety measures. In some cases, scheduled stops were eliminated without notice. In others, a dangerous practice arose where a steamboat would deploy a small boat on a line to swing into docks to hurriedly pick up and discharge passengers while the steamboat continued without pause. Picture doing that in long skirts. There were a series of devastating boiler explosions with shocking loss of life, as well as accidents in the 1840s and 1850s that killed hundreds, including fires aboard the Lexington, a crash and fire destroying the Swallow, a fire aboard the Henry Clay while racing with the Armenia. As we will hear, government regulations were enacted to address the issue of steamboat safety. The number of steamboats on the Hudson increased rapidly to 100 in 1840 and 140 in 1850. Passenger boats increased in length, capacity, comfort, and speed. Bulk freight, much of which arrived on the river via the new canals, was typically carried to market in canal boats formed up into long tows, led by slow but powerful steam towboats. Inexpensive water transportation facilitated the movement of bulk freights, including grain, cement, lumber, and bluestone, and gave rise to a greatly expanded brick industry along the river's clay shores. Western rivers experienced even greater expansion. In 1826, 143 steamboats operated on the Mississippi and its tributaries. By 1850, there were 6,000. The economic implications of burgeoning steam navigation in the United States cannot be overstated. In New York State, the combination of canals and steamboats on the rivers and lakes opened up the Great Lakes region to settlement and trade making in New York City, making New York City one of the world's great port cities and an international center of capital and finance. In a similar manner, steam navigation on the western rivers led to the rapid development of the region drained by the Mississippi and the rise of cities in the nation's interior. As the 19th century progressed, railroads, some owned by steamboat capitalists, began carrying some of the freight and passengers previously served by steamboats. Passenger steamboats, however, remained viable well into the 20th century, and for decades, railroads and steamboat companies maintained symbiotic relationships. Competition and economies of scale reduced transportation costs for freight, and passengers, making farming and manufacturing more profitable and personal travel more affordable. In an era when wages remained relatively constant, average fares between Albany and New York generally declined. Before steamboats, sloop passage with board cost as much as $6.50, and a stagecoach cost $6. The Fulton Livingston boats initially charged $7 for the 150-mile trip. By 1850, passenger rates eventually stabilized at about $1, although tickets sometimes sold for half as much in the face of direct competition. After the Civil War, fares leveled off at about $2 and changed little for decades. By today's standards, these rates seem very affordable until one realizes that a carpenter earned about $1.50 per day in 1860 and a steamboat pilot less than $2 per day in 1864. The Hudson River and steam navigation offered a new gateway to New York's early leisure travel. New York's summers were often hot and humid, and those with means began to escape to mineral spring communities above or west of Albany and to mountain resorts, especially the Catskills. The first of these latter resorts, the famous Catskill Mountain House, opened on the dramatic edge of a cliff in 1824, the same year in which the Fulton Livingston monopoly was broken. Steamboats also facilitated business travel and immigration, especially in the years before the completion of the first railroad to parallel the river in 1851. The rich were able to move their homes outside of New York and to commute to their businesses by steamboat, spurring the construction of new and grand estates with spacious grounds. Steamboats evolved into fast and comfortable floating palaces, many with passenger capacities of 1,500 or more. The St. John of 1864 was nearly 400 feet in length. Specialized night boats picked up passengers early evenings in Albany and New York and delivered them to their destinations after a good meal and a peaceful rest. They remained popular even after the railroads offered faster alternatives. In the 20th century, the largest passenger steamboats, the Hudson River Flyers, carried 3,000 or more passengers each at speeds of up to 25 miles per hour. Technological and economic changes over the years gradually reduced demand for long-distance steamboat travel. However, shorter and less expensive summer excursion trips to amusement parks and picnic grounds remained popular for urban families. Many were looking for inexpensive day trips to river parks at Indian Point, Bear Mountain, or Kingston Point Park. Shorter excursions were available to beaches and amusement parks in New Jersey, Coney Island, and Long Island Sound. Families of less means resorted to short Sunday excursions aboard hay barges towed by steam tugs or steamboats. Inevitably, as operating costs increased, passenger steamboats began to lose their profitability. The Hudson River Day Line discontinued regular runs to Albany while trying to maintain service on shorter routes. Many people gradually turned away from the Hudson River as a source of recreation as it became increasingly blighted and polluted. Distant attractions became easier to access by car, bus, train, and plane. The last of the great steamboats, the 1824 steam sidewheeler Alexander Hamilton, made her final passenger run in 1971. Steam technology was gradually replaced after World War II by less expensive diesel propulsion. The Alexander Hamilton, owned by New York's Circle Line, was replaced in 1972 by the diesel propeller excursion boat MV Dayliner. Freight transportation on the river continued to remain important in the regional economies here on the Hudson River, as well as on the Mississippi. Today's extensive river towing industry, employing powerful diesel tugboats, and the increasingly popular fall leaf cruises among smaller diesel cruise ships remain distant echoes of the mechanical revolution inaugurated on the Hudson River in 1807. Following the final run of the Alexander Hamilton in September 1971, she was laid up briefly at South Street Seaport and later the Brooklyn Navy Yard, as efforts by steamboat enthusiasts were made to preserve her. She was eventually towed to Atlantic Highlands, New Jersey, where she sank in a storm and was extensively damaged. Her sinking ended any practical efforts to preserve her and led to the establishment of the Hudson River Maritime Museum in 1979 to preserve her history and that of the many steamboats that came before her. A New York State chartered institution, the museum is dedicated to the preservation of the river's broadly based maritime heritage and has become a place where people can learn about, protect, and enjoy the Hudson River. Among the museum's proudest recent accomplishments was the construction and launch of the first all-solar electric excursion boat to be licensed by the Coast Guard to carry passengers in the United States. The Solaris we consider to be our generation's Claremont and has succeeded in demonstrating the practicality of solar power on the water. She provides our guests with a clean and silent means of enjoying the river. We invite everyone to visit us at the Hudson River Maritime Museum for a boat ride and an exploration of our programs and exhibits. And on the front table, you'll find tickets to come to the museum. So, thank you.
Thank you very much, Dr. Les. Now, please join me in welcoming Judge Rosenblatt.
Carl, do we know when, I remember not that long ago, the Circle Line would go from New York to Poughkeepsie. And I remember, it seemed like yesterday. When did they go out of business? Do we know?
I'm sure somebody does, but I don't right off the top of my head. And I know that they were running to Bear Mountain even after they stopped running to Poughkeepsie. So.
Yeah. So the Hudson River, which is the nation's first river, named after Henry Hudson, who came upon it in 1607 or so, was a major cultural, political artery, a commercial artery for generations. And the Hudson River, maybe around, let's say, 1900 or so, would have been at a peak of sorts with the steamboats, not to mention the Poughkeepsie Regatta, which was one of the major sports events in the country and in the world, in which the great crews would come and race on the Hudson. There's still crew races on the Hudson, but not of that caliber. They moved to other locations because the Hudson's tide was a little bit uneven, and the coaches of these great crews did not want to be on a river in which the outcome of the race might too much depend on which lane you were in, rather than have a lake like glass, and it would be a more even playing field. So they're now in Worcester and I think in Marietta, Ohio, in what used to be the Poughkeepsie Regatta, one of the great events on the Hudson. So looking back over the advent of the steamship, imagine the impression this created when we had been for centuries on the water, rowing, and then sailing with large masts and commercial ships, sailboats. And then when the steamboat was invented, it's not clear to me who invented it. We hear someone named Fitch. You mentioned someone else as the inventor. Was
they were all working on the development of it at the same time.
So it's hard to say if there's any single person.
Right.
But Fitch was one of them. And I happened to run across the name Fitch. I thought that was important because that ties into our historical legal program today. Fitch had designed a steamboat, and in 1787, in March of 1787, he was granted the exclusive right, a monopoly for 14 years along the Hudson. The date March 1787 is pivotal in this because, as we know, the United States Constitution was drafted in September of 1787. New York was in no hurry to join the Union because New York was doing so well financially with the impost in which it was making money as an active port, that we were not in a hurry to join the Union. There was other reasons, of course, but that's another story for another day, including that the original Constitution had no Bill of Rights. That did not come until the first Congress, based on a promise that James Madison made to the New York delegation in 1788, again in Poughkeepsie. And so when the steamboat arrived after centuries of pulling oars and going by sail, imagine the impression that that made. A vehicle that could traverse and navigate at speeds of 5 miles an hour. Nobody could possibly row that fast. I don't think any of the crews could even row that fast, although who knows, maybe they could. And so in 1787, when Fitch was granted a monopoly, it was easy for New York to grant that monopoly. It was before the Constitution. It was before the words Commerce Clause even existed. So New York felt entirely free to grant anyone a license because New York felt that they were in charge of regulating their own river. That did not change until after the litigation began that ultimately reached the United States Supreme Court in Gibbons against Ogden. So that by the time the first monopoly had been successfully used along the Hudson, that monopoly then was extended to Chancellor Livingston and Robert Fulton. So they had a monopoly also. When I saw that Chancellor Livingston was in the steamboat business, I cringed a little bit, thinking, oh my goodness, they were a little bit looser about conflicts of interest in those days than we are today. But I'm thinking, what in the world is Chancellor Livingston doing, getting a monopoly on the river as chancellor? But I was comforted to know that this was after he had left public life and that he went into the steamboat business. I was really much relieved to see that. So the lawsuits, one of the early lawsuits was in 1811 when Livingston and Fulton sued somebody named Van Ingen. And if anybody wants to pursue any of this, you can find these cases online, Livingston and Fulton versus Van Ingen. And our courts had no trouble in upholding the monopoly. And the Chancellor Kent, followed by the New York Supreme Court, then granted that monopoly, and they enjoined Van Ingen from trying to break the monopoly. This continued on for a while until an entrepreneur named Thomas Gibbons, after the United States Constitution was written, brought on a lawsuit to try to break the monopoly. He knew, I guess he was on very good grounds. I think he was, yes, he was represented by Daniel Webster, as I recall. Professor, does that sound right? Yes. Yes, yeah, good, okay. Represented by Daniel Webster. And New York's argument before the United States Supreme Court went something like this. We're New York, we have a right to navigate, to police, and to regulate our own river. And the other side says, well, yeah, but what about the Commerce Clause? What about the vision of a nation in which no state should be able to control what is really national commerce? And New York said, well, we have double taxation. We have a federal government. They can tax people, but we also in New York can tax people. So that means we can have concurrent regulation. The federals can regulate and we can regulate. This argument had maybe surface appeal, but John Marshall and the court did not buy it. They said, in effect, you can't have two regulators of one river. It's just not going to work. And hence they wrote the decision in Gibbons against Ogden. Not an easy read. It's a very lengthy decision. I started reading part of it. Reading this 40-page Gibbons against Ogden and a glass of milk will put you to sleep pretty quick. But for the experts in the room, I'm sure you can read it with great avidity and read it as legal scholars. I had trouble getting through it. But the one thing that I did take away from Gibbons against Ogden was something that really was at the heart of the formation of our nation, and that is that we no longer consider ourselves an aggregation of states as we began, but we were stitched together as a nation by the United States Constitution and a series of decisions by the Marshall Court over the years that created federalism more so than individual states' rights. We're now in an era where, as there are shifts in the pendulum from time to time, the states asserted themselves in the slavery era by passing personal liberty laws to fight against the Fugitive Slave Act of 1850. So the states were heard from. And I think we're now about to enter a new era in which states, in their state constitutions, are writing provisions to, in effect, undo Dobbs, which had killed off Roe against Wade. So I think we may be seeing a new era of states' rights and state courts and state constitutionalism. But that's a little bit off the mark. My takeaway from it is that Gibbons against Ogden is a great decision by a very thoughtful judge whose vision of America is the vision that we have today as one nation, indivisible. That was John Marshall's vision, and that is what we feel as Americans. I say there are exceptions from time to time when the states assert themselves, but we really are a nation, and I think that was my personal takeaway from the Marshall decision in Gibbons against Ogden.
Thank you, Judge. Now we're going to try to tie some of this together post Gibbons with a presentation by Brian O'Connor. So won't you please join me in welcoming Brian O'Connor.
Thank you. The book is Death by Fire and Ice, the Steamboat, Lexington Calamity. And what I was going to just start by saying, the cover, this is a lithograph that was done by Nathaniel Currier, then an unknown lithographer from Boston who was working in New York. And it was published a few days after the Lexington sank by the New York Sun, which is at the time the city's largest newspaper. And it was widely acclaimed. And that really launched Nathaniel Currier's career. It wasn't until 1857 that he wound up partnering with James Ives that went on as Currier and Ives to a great fortune and fame. The point of my talk is going to be mainly about the regulation of steamboat safety and other legal aspects of this. I'll try during the course of to give you a little flavor about the Lexington itself and the catastrophe, because I think it's a great humanitarian story. But as we've heard, it was Gibbons versus Ogden which really opened the door to competition in New York. And up until 1815, most of the steamboats in the New York area were low-pressure engines. They generate only 2 to 4 pounds per square inch of pressure. And that began to change when in 1811, a man by the name of Thomas Evans invented the high-pressure steam engine, which was capable of generating up to 150 pounds of pressure per square inch. When he did that, it became apparent for the first time that steamboats could navigate not only the rivers, but maybe they could navigate Long Island Sound, the ocean, because they would have a greater strength and speed to be able to encounter the rougher waters. The story about steamboat regulation really starts with the fact that once the monopoly was ended and competition began, particularly on Long Island Sound, and the combination of having steamboats which had high pressure engines, all sorts of terrible things occurred. There were one accident after another with truly devastating results. The first one was in 1824, just after Gibbons versus Ogden. There was a steamboat, the Etna, which was servicing the waters between New York City and New Jersey. And in May of 1824, it was approaching New York when its center boiler exploded, sending steam and scalding water throughout the boat. Fortunately, there had only been 34 passengers on board and only 9 died. But shortly after that, in 1837, there was another boat, the Ben Sherrod, which was known as a cotton boat, which was made to transport not only passengers, but cotton. It had 235 passengers on board and 15 to 2,000 bales of cotton. It was en route from New Orleans to St. Louis. It was racing another steamboat. The cotton on board ignited, and more than 200 perished. Another, the Helen McGregor in 1830, was en route from New Orleans to Louisville, 460 passengers on board. The passengers were dining, just enjoying their breakfast, when one of the boilers exploded, tearing a hole throughout the boat and killing 40 to 50 passengers. Just a couple more, the Moselle in 1838, another steamboat, the boiler exploded, more than 180 were killed, and the newspaper articles at the time described the carnage. Bodies were blown onshore, were even found limbs on the top of buildings. The force of these explosions was that graphic. And finally, in 1838, the Pulaski was another boat en route from Savannah to Baltimore with 200 passengers. Her boiler exploded, killing about 180 passengers. At that point, there began to have cries between 1824 and 1838 by the public to do something about this, to have some form of legislation that would protect the passengers on steamboats. The problem at the time is there were a number of bills that were introduced in Congress between 1824 and 1838, but there was a reluctance on the part of Congress to legislate. There were two things to it. One, as the judge has said, this was an incredible invention, and this was really the first invention that the common man really saw the benefit of in the Industrial Revolution in the United States. And there was a concern that Congress didn't want to step on the toes of the entrepreneurs that had been brilliant enough to invent this. And the thought was that it was in their interest to try to mitigate losses and deaths for their own limitation liability, and that they would over time get this right. And who was the congressman who had no scientific background? Who were they to begin to tell the entrepreneurs how to operate steamboats? The second hesitance to legislate was there were some concerns about whether Congress had the power to legislate about steamboat safety. True, there was Gibbons versus Ogden, but some argued that that was really a question of commerce, whether or not a boat could operate in the waters at all. But when you talked about what kind of safety provisions were necessary in a boat, that sounded to some like that was really part of the police powers. That was really part of the powers reserved to the states under the 10th Amendment, and maybe Congress didn't have the power to legislate those safety issues at all. Finally, though, by 1838, with the last of the incidents I described, Congress had to do something. So they decided to take kind of a middle course. Rather than enacting a substantive statute that set forth specific parameters and details for how steamboats had to be operated, what type of safety equipment they needed, they decided to have what I would call a procedural statute. It required a registration under the Coasting Trade and Fisheries Act of 1793. There had to be a license granted to each steamboat. And to get that license, there were two inspections that were required. The inspectors were appointed by the U.S. district courts in the various ports. And one inspection was done on an annual basis. That was to inspect the hull. And the inspector had to issue a certificate that the hull was fit and sound and seaworthy. The second certificate was a certificate that had to be issued about the ship's boiler. And again, that was done semi-annually, and the inspector had to certify that the boiler was sound and fit. The problem with the statute was that there really were no parameters in the statute for how the inspectors were to determine either that the hull was fit and sound or that the boiler was fit and sound. Much of it was left to the discretion of the inspectors. Fast forward then for a moment, then you've heard about Gibbons versus Ogden and the connection with Commodore Vanderbilt. Commodore Vanderbilt was approached by Thomas Gibbons in 1817 to command the steamboat that he was operating between New York and New Jersey in competition with Ogden. Ogden was the party that had the license from Fulton and Livingston. Gibbons did not. And although Vanderbilt had no experience captaining a steamboat before, he'd only dealt with sailboats, he agreed to captain the boat. And at that point, it was he that was captaining the boat when the Gibbons versus Ogden litigation occurred. So he got a feeling for the steamboat, and although he at some point left the employ then of Gibbons, he decided that this sounded like a lucrative thing to do, so that he began to consider operating a steamboat in Long Island Sound. And that was important at the time because in 1835, when Vanderbilt decided to build his steamboat to Lexington, there was no railroad service between New York City and Boston. It wasn't until 1835 that the Boston and Providence Railroad line opened and started daily service between Boston and Providence. 2 years later, in 1837, the Providence and Stonington Railroad line opened, extending the rail service from Boston to Providence to Stonington. That, for the first time, then offered an ability for people to travel. They couldn't go directly from Boston to New York by the railroad, but they could take a steamboat from New York to either Stonington or to Providence, and then instead of having to go by stagecoach, the railroads would meet them in Stonington and Providence and transport them the rest of the way to Boston. And this became important for not only passengers, but for freight, particularly cotton. Cotton was a big commodity, and it was generally shipped up from the south to New York, and then from New York on the steamboats to either Stonington or to Providence, and then by rail to Boston for use either in the New England textile mills or to be exported to Europe. So in 1835, Vanderbilt decided to build the Lexington. He hired a very prominent builder in New York, Bishop and Simonson. There was no written contract. There was no agreed upon purchase price. He simply provided Bishop and Simonson with a design model that he had done himself and told them to make the boat as strong as possible and to use the finest materials available. They did so. It was 205 feet long, 22-foot beam, 140 horsepower engine, and it cost Vanderbilt $75,000, or about $2.1 million in today's dollars. It made its maiden voyage between New York and Providence in June of 1835, a 210-mile trip. It did it in 12 hours and 28 minutes with a top speed of 20 miles per hour. In command of the boat that day was Vanderbilt's younger brother, Jacob. Vanderbilt continued in 1835 rather, through 1839, running the boat, the steamboat, the Lexington on Long Island Sound. But there was an intense competition at that point in the Sound. There was a company called the Boston and New York Transportation Company. They were running several boats in competition, and fair wars broke out. Vanderbilt was ruthless in trying to cut prices to drive his competitors out. In the end, it was the transportation company that approached Vanderbilt and offered to buy him out, pay him $70,000 to buy the Lexington and to eliminate it as a competitor. So he sold the boat in 1839 to the transportation company, and that was in January of 1839. The Lexington was inspected in October of 1839, pursuant to the 1838 statute. It passed with flying colors. The two inspectors certified that the hull was sound, the boiler was sound, and she was ready to go, with one exception. Later in that year, in November 1839, 1 month after the inspection, the new owner, which by that time was called the New Jersey Steam Navigation Company due to a merger, decided to pull the boat out of the water, to repair it and to overhaul it. And the principal repair or modification that it made was the Lexington's furnace. The new owner wanted to change the furnace in a way that it thought would burn coal more efficiently. Up to this point, most steamboats burned wood, but wood was a problem. It was bulky, it was expensive, and they began to look for other sources of fuel. Soft coal or anthracite replaced wood, and the new owner of the Lexington wanted to improve the efficiency of the Lexington's furnace. It did that really two ways. It raised the grates in the furnace, and it also installed another blower, which would produce a much greater draft. And with that, the Lexington was ready to go. Interestingly, it was not inspected again after that modification. There was nothing in the 1838 Act that required any type of an interim inspection after any material repair or modification had been made. So we come to the point then, we're now in January 13th, 1840. The Lexington is scheduled to depart from New York for Stonington at 4 o'clock that day. By all accounts, it was an absolutely frigid day. In the morning, it was almost zero. By evening, it was minus 17 degrees. It was planned to leave at 4 p.m. It had a crew of 34. There were approximately 113 passengers on board. There's some ambiguity about the number because no one actually knew for sure how many people were on the boat, but I think 113 is a good estimate. It was also loaded with 150 bales of cotton, and also some specie and banknotes owned by the Merchants Bank of Boston. Just a couple of points about the role of fate that day. Two interesting things occurred. Despite the sale of the boat by Vanderbilt to the New Jersey Transportation Company, his brother, Jacob, remained the captain of the boat. But that day, he had a cold and was too sick to command the boat. So a new captain by the name of George Child replaced him. Child, by all accounts, had been employed by the company before. He was an experienced captain, but he had never captained the Lexington before and was probably unfamiliar with the crew. The second interesting occurrence of fate was Henry Wadsworth Longfellow had just recently written The Wreck of the Hesperus. In December of 1839, he was sitting in front of a fire. He had this inspiration to write a poem about a shipwreck. He wrote the poem, finished it at about 12 midnight, went to bed. Something woke him up. He decided to go back and modify it a bit, which he did. He finished at 3 o'clock in the morning, which you'll learn in a moment was the precise time that the Lexington went down. And that day of January 13, 1840, he was in New York. He was meeting with his publisher for The Wreck of the Hesperus, and he had bought a ticket for the Lexington to return to Stonington, Connecticut. And as it turned out, the meeting went late, and he missed the boat. Now, there was reports at the time that he was on board the boat, appeared in the New York papers at the time that he was on board, and he had to write a letter to his father a few days after this, telling him, "Don't worry, I missed the boat, I'm fine," and the papers just got it wrong. So at a little bit after 4 o'clock, the Lexington cast off. As I said, it was a terribly cold day. There was ice in New York Harbor, ice in the East River. It steamed up the East River, out under through where the Frog's Neck is now and out into Long Island Sound. It was extremely cold, and they got just about to Oyster Bay, and I live on Eaton's Neck, which is just east of Oyster Bay. And at about 7 o'clock, the cry of fire broke out. It turned out that the steam chimney had turned red hot, and the casing around the chimney had gone on fire. Some of the cotton had become ignited, and the crew immediately then tried to extinguish the fire, and it was just one parade of unfortunate horribles after the other. First of all, they had something called a fire engine, which was an engine with a hose that was supposed to suck water from the sound to put the fire out. They tried to use that. The problem with it was that that was only operational if the boat was traveling less than 5 miles an hour. At this point, the Lexington was still doing somewhere between 14 and 20 miles an hour, and as a result, the fire hose just didn't work. They then went and tried to use their water buckets. The boat had 50 or 60 water buckets on board. They tried putting the water out. Some accounts said that the water buckets, not surprisingly, might have been frozen given the fact it was minus 17 degrees. Others said they weren't, but they lowered buckets down to the sound with unfrozen water, but they couldn't put the fire out. Next, they decided that they would try to get the passengers off the boat. The boat was equipped with a lifeboat and on the bow and 2 quarter boats, which, according to the accounts, would have been sufficient to take all of the crew and passengers off. But again, problems emerged. The boat was continuing to proceed. I think at that point the captain was thinking that the fire was really raging, that he might have to beach the boat on Eaton's Neck, and he wanted to get the boat as close to the shore as he could. So he didn't slow the boat down. And so then when they lowered the lifeboat from the bow, it wasn't lashed properly to the Lexington. When it hit the water, it foundered and drifted away into the night without anybody being able to get off the boat. They then went to the 2 quarter boats. Same thing happened. The boat was going too fast. People were, by this time, panicking. People were jumping into the boat. They lowered the boats down, and again, they foundered and drifted off into the night. Now, at this point, the only chance that the captain thought, Captain Child, was they had to get to Eaton's Neck and beach the boat. Unfortunately, as they tried to do that, in the wheelhouse, they felt something snap. It turned out that the fire by that point had burned through the ropes that connected the wheelhouse to the tiller, and the boat became completely unmanageable. With that, now they were completely at a loss. The boats were gone. They couldn't get to shore, and next the engine stopped, and they were at the whim of the current and the wind, and they slowly drifted out away from Eaton's Neck into the middle of the Sound. The descriptions of the 4 survivors, which I'll get to in a moment, were horrific about what these poor people did. There were women and children on board. They were faced with this ever encroaching fire. They either had to cling to the boat and burn, or jump into the Sound and likely freeze to death within minutes, given the temperature of the water. And there was absolutely a clear night. There was no other boats out there, so there was really no hope of any type of a rescue at any time soon. And by 3 a.m., the boat had drifted out, basically out to along the line of where the Bridgeport, Port Jefferson ferry is today, and it then sank, and whoever was left on board was jumped into the water. Now, 4 people out of the whole 34 crew and the 113 passengers survived. 3 were members of the crew, and 1 was a passenger. And they had survived by throwing some of the bales of cotton over the board and climbing onto the bale of cotton in the hopes of staying on top and out of the water until maybe a boat would rescue them the next day. Interestingly, the 1 member of the crew, David Crowley, or let me go back. The three of the 4 were picked up the next morning by a boat that came out of Southport, Connecticut, and found them. The 4th guy drifted off on the bale of cotton, and he drifted back and forth for 3 days in Long Island Sound. 1 minute the tide and the wind was blowing him towards Connecticut, then it reversed and took him the other way. He wound up washing up in Riverhead 3 days later, and did manage to survive. And of all the people who were lost, there was only 15 or 16 bodies that were ever recovered. I think the reason for that was There was ice on the top of the water. The current just washed the bodies out into the Atlantic, and they weren't found. In those days, the New York City coroner was tasked with holding an inquest to determine when a body was found in the city and there was no explanation for what had happened, how they died, to hold an inquest. And within a couple of days of the Lexington, which was published in all the papers, the whole calamity, the coroner convened a 14-member jury, and they held an 8-day hearing at which 18 witnesses were called. Vanderbilt testified about the boat as he built it. The new owners testified about what they had done to convert the boat to burn coal more efficiently. The steamboat inspectors testified about what they did and why they thought the boat was fit for service. And the survivors testified about what they had observed and what they thought had been the cause of the fire. It didn't take long for the jury to come to a conclusion, about a day and a half, and the jury's verdict was absolutely scathing. The jury concluded that the fire was caused by the intense heat of the smoke pipe or the chimney, that the furnace had been suitable for burning wood but not coal, that once the blower had been added, it increased the heat to an excessive degree. The jury condemned what they called the odious practice of carrying cotton on passenger boats and said that deserved public censure. They really had it out for the Lexington's owner, the crew, and the U.S. inspectors. They said that the fire could have been extinguished had the captain slowed the boat properly and used the fire engine properly. That if he had slowed the boat, they should have been able to put down the lifeboat and the 2 quarter boats, and everyone could have been saved. And they said the officer's conduct deserved the severest censure of the community. And what they were getting at was, at one point, Captain Child had gone to the stern of the boat to put down one of the quarter boats, and he was last seen on the quarter boat. And I think they thought that he had decided to abandon ship and didn't stay with the crew and the passengers as he should have, and they had it out for him. And as to the steamboat inspectors, they said that it was either through ignorance or neglect that they had certified that the boat was safe when it was not. Well, the press went crazy with that. The press said that the inquest evidence was sufficient to convict the Lexington's owner, her officers, and the U.S. steamboat inspectors of wholesale murder. And they meant not manslaughter, not negligence. They meant intentional murder. Within weeks, there were calls in Congress to pass legislation to amend the Steamboat Act of 1838. And interestingly, even though those were the calls, it was not an amendment to the Steamboat Act that occurred first. Instead, there was legislation passed by Congress to limit the ship owner's liability, in this case, the Lexington's liability for the loss of the value of the cargo on board. And where that comes from is when you think about it, you go back and think, well, what could have happened after this scathing jury verdict, calling for indictments? Well, there were no indictments. And I think the reason for that was the only statute, the 1838 Act, by its express terms, talked about people that were on board the boat, the officers, the crew who were negligent. It didn't say anything about directors or officers of the corporation that were not on board. It didn't say anything about the inspectors. So no indictments occurred. In terms of civil liability, you'd say, well, what about the 113 people, or 143 people who died? And didn't the company face actions for personal injury? And of course, in those days, until 1849, when New York State became the first state to enact a wrongful death statute, those actions for personal injuries expired with the death of the victim. So there were no claims by the deceased people. So that left you with the 4 passengers, the 4 survivors. Well, 3 of those were crew members. They probably would face a contributory negligence defense. They never sued. They didn't have any money anyway. The only one who might have was the non-crew passenger, but there's no record that he ever did that. So what did occur? Well, the Merchants Bank of Boston sued, and they wanted to recover the value of their lost specie and the banknotes. And that case didn't go through the New York courts. It went through the Admiralty jurisdiction in the federal court in Rhode Island. And the courts held that the owners of the Lexington should be held liable. The case went to the Supreme Court, and the Supreme Court concluded fairly quickly that they felt that the Lexington's owners should be liable, that they had been negligent in the management and operation of the boat. Well, of course, that sparked an outcry in the New England from the shipbuilding states and maritime states like Massachusetts, Maine, and others. And they quickly lobbied Congress to pass some type of a statute that would limit the liability of ship owners so that they would only lose the salvage value of their own ship and the amount that they had received as payment for freight on the ship. And Congress, in fact, went ahead and did pass the Limitations Liability Act. And in fact, in the original congressional record, there's a footnote that makes it clear that this act was intended to legislatively overrule the Supreme Court's decision in the Lexington. And what they then said was that, no, ship owners couldn't be held liable for the value of the cargo unless they had done something negligent. And it couldn't be based upon the negligence of the people on the boat, like the captain or the crew. So as odd as it sounds, and this was in 1851, the first legislation that was passed by Congress after the calamity of the Lexington was not to improve passenger safety, but to limit the liability of ship owners. Understandably, they were concerned that if they didn't do that, it was so costly to build these boats that maybe our maritime industry would suffer. So they passed the Limitations Liability Act. The issue of the safety of passengers after the Lexington came up again in 1850. There was a ship called the G.P. Griffith. It was departed Buffalo for Cleveland in 1850 with 300 passengers on board. While she was underway, she caught fire. The crew was unable to extinguish it. The crew tried to beach her, but the engine stopped and they ran aground a mile from shore. People jumped off the boat like the Lexington to escape the fire. 285 people died. The Henry Clay, which you heard reference to today, in 1852, she was en route to New York City down the Hudson River. Again, she caught fire near Yonkers. The crew couldn't extinguish it. The captain tried to beach her on the New York shore, ran aground again too far off, and people again were forced to either burn on the ship or to jump into the Hudson. More than 80 perished. That was enough at that point then for the Congress to go back, and in 1852, it passed a revised amended Steamboat Act to try to deal with some of the inadequacies in the 1838 statute. And this time they tried to do not just a procedural regulation, but they tried to put some substantive parameters into the statute. So there were specific requirements for testing boilers, subjecting them to hydrostatic pressure, annually testing. They mandated specific firefighting and safety equipment, fire pumps, lifeboats, life preservers, which had not been required by the 1838 Act. They banned carrying certain cargo like gunpowder and other explosive fluids without a special license. They banned carrying hemp unless it was compacted and covered. But interestingly, they said nothing about cotton cargo. Despite the Lexington, there was nothing in the 1852 Act that required cotton cargo to be treated like hemp was, to be completely covered and compacted to lessen or mitigate the chance that it would catch fire. The 1852 Act was an improvement, but the carnage continued. Two of the most famous incidents were the Pennsylvania. She was en route in 1858 from New Orleans with 450 passengers. Interestingly, Samuel Clemens of Mark Twain fame was employed on the boat as a cub pilot, kind of an assistant to the pilot, and his brother Henry Clemens was on board as a mud clerk. The name mud clerk came from the fact that as the boats got to shore, some of the mud clerks would jump off into the water to try to tie the boat up, and they'd get their shoes full of mud, and hence the mud clerk. In any event, the Pennsylvania left New Orleans. Again, fate played its role. Mark Twain had a battle with the captain or the pilot he was apprenticed to, and he left the boat, but his brother remained on board. Near Memphis, one of the 4 boilers on the Pennsylvania exploded, tearing the ship apart. 250 people perished, including Henry Clemens, Mark Twain's brother. And then finally, the worst disaster to this day in U.S. maritime history was the Sultana. In 1865, the Civil War had just ended with Appomattox and Lincoln being assassinated at Ford's Theater. The Sultana was tasked with going down the Mississippi River, draped in black bunting to give the news that Lincoln had been assassinated. And when she got down south in Vicksburg, she took on 2,000 Northern prisoners who had been kept by the Confederates, and she was to bring them back home. She only had a legal capacity of 376, but she took on 2,000 prisoners. And after leaving Memphis, one of her boilers exploded, and 1,700 perished in that disaster. As I said, the worst in U.S. history. That led then in 1871 to the last comprehensive amendment of the 1838 and the 1852 Act. And again, this statute specified substantive requirements for safety, again, mandated more specific safety requirements, fire extinguishers, water buckets, life preservers for each passenger. It required annual inspections of boilers to check their tensile strength and ability to withstand changes in temperature. And interestingly, it required wire tiller ropes or iron rods or chains for steering over the entire length of the boat. The Lexington had wire lines down the sides of the boat, but at the very last 10 feet that's connecting to the wheelhouse and the last 10 feet connecting to the tiller, the Lexington had hemp rope. And Congress now said, no, you couldn't have that. You had to have completely iron chains the whole way. And it also then said that any cotton had to be compressed, baled, and covered with bagging and well secured. And so in the end, after the Limitations of Liability Act for the owners had been passed, and it took to the second attempt by Congress to get the 1838 Act right, but the two principal causes probably for the real tragedy of the Lexington, the fact that the ropes burned and she became completely unmanageable and drifted out into the sound, and the fact that the cotton bales were unprotected and really just caused the ship to go up like a tinderbox. Congress, it took 31 years, but they had finally addressed probably the two principal causes for the Lexington's demise.
Oh, okay.
Thank you very much, Brian, for that very, very interesting and detailed account. Very fascinating stories. I would like to try to address the Commerce Clause itself and track a little bit of its history from 1824 when Gibbons was decided to the present. Professor Richard Primus, in his essay, The Gibbons Fallacy, states, "Every living American lawyer learned in law school to confront the Commerce Clause issues first and foremost as issues about the extent of Congress's power to regulate." This was referenced by Judge Rosenblatt in his opening remarks about the cases starting with Champion versus Ames, which had decided that lottery tickets were commerce and therefore subject to federal regulation. The key on my slides is that Those cases in black upheld the actions by Congress or the states in the case of later slides, and the ones in red are where the court struck it down. But the pendulum soon swung in Hammer versus Dagenhart, which held that the child labor laws were contrary to the scope of congressional power, and therefore invalidated those laws. The New Deal cases and U.S. versus Darby in 1941 actually reversed Hammer, upholding the Fair Labor Standards Act. So you see the pendulum swinging back and forth, where the Supreme Court is trying to find out where does the congressional power marker stand. Well, it was from 1935 to 1995, a period where basically there were no federal statutes struck down by the Supreme Court as exceeding congressional power to regulate under the Commerce Clause. And then came, as the judge referred to, U.S. versus Lopez in 1995, which held that Congress had overstepped its bounds on the Gun-Free School Zone Act, which was then followed 5 years later by U.S. versus Morrison, which held that the Federal Violence Against Women Act had exceeded the congressional power. And 12 years later, under the Sebelius case, we find that the Supreme Court specifically ruling that the U.S. Congress had insufficient power under the Commerce Clause to enact the mandate under Obamacare, but it did find that it had under its taxing power the ability to do that. So what happened in the 19th century in the context of attacks on congressional legislation as exceeding the power of Congress to legislate under the Commerce Clause? Well, the short answer is not very much. As Brian had indicated, that there was very, very little federal legislation at the outset of the nation for the reasons Brian mentioned, reluctance by Congress to interfere with the entrepreneurs and with the business building of the country. So really it was not until Ames that there was a serious attempt to address the constitutionality of federal laws. Where the action was, however, in the 19th century, was testing the constitutionality of state laws. The cornerstone case is Gibbons, and following Gibbons was the Blackburn case, where the notion of dormant Commerce Clause, which I'll mention in a moment, came up. And through the licensing and passenger cases, the court wrestled with the notion of whether the Supreme Court's consideration under Gibbons was an exclusive power given to Congress to regulate interstate commerce, or was it shared? Was there concurrent jurisdiction? And it wasn't until 1852 in the Cooley case that the court finally found its bearings to say that, yes, under certain circumstances, the state could regulate interstate commerce so long as there wasn't a direct federal legislation to the contrary. Turning to the late 1900s and the early 20th century, we find that the Supreme Court has started to expand on this notion that there may be an aspect to the Commerce Clause that is not expressed in the Constitution itself. Article 1 says that Congress shall have the power to regulate commerce among the several states. So that's an affirmative grant. But soon, the Supreme Court also recognized that there was a negative aspect to the Commerce Clause power that prohibited states from interfering with interstate commerce. And once the concept of the Dormant Commerce Clause came to the forefront, that is where the Supreme Court from the 19th into the 20th century started to develop its jurisprudence around the parameters under which an individual state could regulate commerce. So by the late 1800s and early 1900s, it became very clear that wherever there were laws that involved the actual discrimination, so one state trying to better itself economically over another state, that those laws would be found to have exceeded the power of the state to do it and run afoul of the Dormant Commerce Clause. The cases cited here, Weber against Virginia, and the subsequent cases were mostly price regulation cases. So that in one instance, in Brown against Foreman, New York State passed a law that said basically dealers in certain products would not be allowed to sell products in New York State where the supplier, who is out of state, did not provide a most favored nation status to the pricing to give the benefit to the New York State residents. Well, that was found to have crossed the line and to be illegal. And subsequently, the Supreme Court then further refined the Dormant Commerce Clause approach to attack state laws that were targeting non-discriminatory actions by the state that would in effect impact the commerce between various states. And the seminal case here was decided by the Supreme Court in 1970, Pike versus Bruce Church, which basically laid down the rule that the court would strike a law if the burden on out-of-state sellers greatly exceeded local gains. Otherwise, the law would be presumptively valid. The Supreme Court also introduced in the mid-1900s the concept that any state laws that would actually interfere with the transportation between states would be found to violate the Dormant Commerce Clause. And you may have remembered from the law school days the mudflap case. So if one state required mud flaps of a certain specification, another trucker coming into the state of Arizona would have to literally stop at the border, change the mud flaps on the truck, and proceed in through that state. The court found that that had crossed the line and that was not going to be allowed. So where does the Dormant Commerce Clause land today? May be of interest to those that the Dormant Commerce Clause has reared its head in the medical and recreational cannabis arena. So state laws have been enacted, including in New York State, which provide residency requirements in order to obtain licenses to sell medical or recreational cannabis. In the state of Maine, there was a case that was brought before the First Circuit where the medical marijuana dispensers, the petitioner was a non-Maine resident, and the First Circuit held that requiring a in-state residency in order to obtain a license was a violation of the Dormant Commerce Clause. Closer to home in the Northern District of New York, the recreational cannabis case of Veracity was struck down by the district court, where the claim was that the recreational marijuana licensing requirement that an individual have certain contacts to New York State was found to violate the Dormant Commerce Clause. The state appealed, and you may have read in the newspapers that as the New York State tried to roll out the recreational, that there were a number of regions, including Brooklyn, the Finger Lakes, and 3 or 4 other regions, that they were prohibited, the state was prohibited from issuing licenses because of the Northern District's preliminary injunction. The state appealed. On appeal, the Second Circuit limited the scope of the preliminary injunction, kept it in place pending determination of the appeal. So now the state was able to issue licenses in 4 of the 5. It's the Finger Lakes that is still subject to the preliminary injunction, and ultimately will be decided by the Second Circuit, which has set forth an expedited briefing schedule. Across the country, the case of Brinkmeyer versus the state of Washington was another recreational residency requirement. But in that particular case, the district court decided that contrary to the First Circuit and contrary to the Northern District, that there was no problem with the Dormant Commerce Clause. And specifically, it found that marijuana is still illegal in under federal law. So how could there be a legitimate market that would be impacted adversely by the state law? So that case was appealed to the Ninth Circuit, but as was recently as 2 weeks ago, was withdrawn. The appeal was withdrawn by the plaintiff, but the Ninth Circuit will get a chance to take a swing at this issue in a number of cases that are percolating up, including a challenge to an Oregon state law that says that you can get a license, but you can't export marijuana out of the state of Oregon. And the purpose supposedly being is that they don't want to get in trouble with the feds. And it's as simple as that. However, the issue of the Dormant Commerce Clause and granting discriminatory favoritism to in-state residents will be one that I think you'll see coming up for the Supreme Court in the near future. What about the other aspect of the non-discriminatory aspect of the Dormant Commerce Clause? There is a case currently before the U.S. Supreme Court, the National Pork Producers Council versus Ross, that arises out of Proposition 12, which is a proposition in California that was passed in the year 2018, which prohibited any out-of-state supplier of uncooked pork to import uncooked pork into the state of California, where the breeding pig was not allowed more than 24 square feet in which to move about. This is pretty hard to imagine what they were talking about, but this was the issue that Proposition 12 addressed itself to. And the pork producers brought a case challenging the law and the proposition on the Dormant Commerce Clause theory. The Ninth Circuit had no problem with sustaining the law, and argument before the U.S. Supreme Court occurred in October, lasted 2 hours, and the justices were very concerned with a number of issues. During the course of the presentation, the pork producers attorney made the argument that, look, here you have an in-state law that's regulating the means of production in a totally different state. How can that be sustained under the Dormant Commerce Clause? As I said, the Ninth Circuit didn't have any problem with it, but the justices on the Supreme Court were all over the map in their questioning. You can actually listen to the oral argument. And their concerns range from being worried that, well, Justice Kagan, for example, asked the question of the petitioner, said, well, what about a law in New York State which says that you can't import firewood into New York State unless you use a certain pesticide? Would that law be invalid? The petitioner took the position that it would be, and that just raised a series of other questions by the judges. Well, what would happen if the state of California or any state required that before you could introduce a product into the state, it had to be the product of union labor? And then what would happen if another state said, well, the product coming into our state had to be a product of non-union labor? The questions raised a variety of issues and made one think back to what brought us here today, Gibbons versus Ogden, where you had a law that pitted New York against New Jersey. For example, in retaliation to the monopoly that was granted to Ogden, Gibbons was able to get the state of New Jersey to pass their own monopoly. So Gibbons had a monopoly from New Jersey and provided that anybody from New York who came to touch the border in New Jersey would have their boat forfeited. So I think the Supreme Court's very sensitive to situations where one state can pit against the other. And stay tuned. Nobody really knows, and I guess we'll find out by the end of next month how the Pork Producers Council case will end up. So like right now, I would like to just invite our panelists to offer a comment or two on anything that you've heard tonight, and then we'll open it up to questions.
Craig had mentioned the passenger cases and the license cases, and the judge had mentioned, and the judge had mentioned how complicated reading the opinion in Gibbons versus Ogden was. And what struck me is how the court really grappled with the Interstate Commerce Clause and how that did interact with the state's police powers under the 10th Amendment. Just quickly, the passenger cases were cases in which certain states had enacted a statute that required captains to register in the ports, to in some cases for the passengers to pay a tax and whatnot. And when the court looked at this, they couldn't come up with a majority opinion in these cases. They were all plurality opinions because some of the judges said, well, wait a second, that's regulating commerce. Other judges said it's not regulating commerce at all. That's police powers. And then in between were judges who then got to the point of whether this was the dormant clause or not. And as long as the federal government hadn't done something or the state wasn't doing something that was, in conflict with the federal government, they could do it. So 200 pages, no one knew what the law was.
How about public reaction to Gibbons versus Ogden? Any reports? Was it welcome news, or did people have problems with it? Brian, do you know?
Well, I would say I thought it was welcome news. It certainly increased the amount of steamboat service in the area, and presumably would have reduced the cost of service to the passengers.
There was some pushback that I'm aware of in the newspapers in response to the opinion, and the concern was that the the boats that had been operating under the monopoly had been very safe. And the concern was, and Brian had referenced the low pressure versus high pressure boilers, that if the monopoly was broken, the newspapers worried, there would be unsafe boats on the waters. And his presentation showed in great detail that's exactly the direction that it went.
Just one comment on that. I agree with it in the sense that there were people who felt that all the problems with these exploding boilers were now, at least in the New York area, not out west, but New York, was because now these steamboats were able to ply the waters of New York. But I think that was kind of short-sighted, because what would have happened if the monopoly had been sustained is the Fulton Livingston people would just have begun to operate high power steam engines, just the same way the competitors did.
Right. There was mention this evening about Daniel Webster as being one of the lawyers for Gibbons. What do we know about the other representatives in Gibbons versus Ogden? In the papers that I read around that time, there was great interest in New York of their team going down to Washington. Any thoughts on the
yeah, there was.
drama?
Unfortunately, his name escapes him, but I think the lawyer on the other side was either a former Solicitor General or somebody, which was a very big time lawyer.
Right. The one I'm thinking of is who was representing Ogden, where it was Thomas Addis Emmett.
Yes.
On one hand, who had been, you're correct, for a time State Attorney General, and his colleague was Thomas Ogden, Oakley, sorry, who is also a New York lawyer, and he had also served as Attorney General. And together with Webster was William Wirt, who was the Attorney General of the United States. You would think, talk about conflict of interest, how can the Attorney General of the United States be arguing cases before the U.S. Supreme Court? But apparently it was quite a common thing early in our history. There was no conflict. The state didn't, the federal government didn't have a concern about the case. But in one of the books written recapping Gibbons, especially on the issue of the argument is whether Congress had the exclusive authority over interstate commerce or whether it was shared, Daniel Webster took the hard line that it was exclusive. And if you read, I agree that the decision by Marshall is a little hard to get through, but you can see that he's leaning towards a finding that of exclusivity. But as it turned out, under Cooley, 25 years later, it was decided that it was shared, which had been argued by the lawyers for Ogden. And so this one scholar that I read said that even though they lost the case, Emmett and Oakley had a more dramatic impact on the jurisprudence of the Commerce Clause, not only for the 25 years, but for the 200 years since it was decided. And the scholar said, not bad for two lawyers who lost their case. So,
I always had a little difficulty in reconciling the limits of the Commerce Clause itself, where in the United States Supreme Court in Lopez and Marcy found that gun-free zones and a law against violence against women were not within interstate commerce. I found that's a little difficult to reconcile with, I don't remember the name of the case, but it seemed like there was a localized decision, in which somebody grows a bushel of wheat on an acre of land, and that was interstate commerce. Anybody remember the name of that case? Which is it? Working against Philbin, right. So can anybody reconcile working against Philbin on the one hand and Lopez and Marcy on the other? I'd like to see anybody reconcile those two cases. I'd be interested in hearing it. A very good explanation. Yeah. Change of membership, huh? Yeah.
Well, we'd like to open the floor to questions. If you could just come up and use the mic. This is being recorded, or we'll bring the mic to you.
Well, what was the vote in Gibbons? Was there dissent? I mean, were there concurring opinions? How did that go?
It went, there were 8 members of the court. The 9th, as it turns out, was Justice Smith Thompson, who was from New York, and he wrote an opinion in the Van Inges case in favor of the monopoly. However, his daughter had just died or was very sick, and he wasn't able to attend oral argument. So it was an 8 judge bench, and 7 voted with Marshall. There was 1 concurrence. And the concurrence basically took the position that the court had exclusive authority, the Congress had exclusive authority over interstate commerce, so it didn't matter. End of case.
Hey, I'm sorry to sound too parochial, but just this past week, by an amazing coincidence, Paul O'Neill, the Commissioner of Jurors of Ulster County, happened to be in the Poughkeepsie Rural Cemetery, and he saw Smith Thompson's grave. Smith Thompson was from Poughkeepsie, and he still has people living in Poughkeepsie. And the gravesite was a mess. There's not even a marker. So the Bar Association just said they're going to raise like $850 and put up a bronze plaque for Smith Thompson's gravesite. What an amazing coincidence. You mentioned it here. This just happened 2 days ago.
Yes, sir.
I would ask you to comment on the difference between interstate commerce now and when the Constitution was drafted. Country was about 4-5 million people with a $4 billion economy. Now we are 330 million people with $17 trillion economy. Can you compare what constituted interstate commerce and what they meant then with what constitutes interstate commerce now, given the way we source products from all over the world, where everything contains something from far away, where everything in a wicked and Philborn manner is affected by whatever else is in the market and where it's coming from, how it's delivered, and all the rest. Don't we need a new, more expansive definition of interstate commerce to suit the times, to suit modern technology, modern commerce?
Anybody want to take a crack at that, Brian?
No, I think that's your call.
Yeah. Okay. I agree that the notion, obviously, is interstate commerce is not the same as it was in the late 1700s. But the concern that supported the desire to have a commerce clause in the first place, I think, is as viable today as it was back then. Their concern in particular was that states that had access to imports would impose certain taxes and make the flow of goods into those states that didn't have access to ports more difficult. And it was very common prior to the Constitution coming along that states would impose their own tariffs on foreign goods. So the Commerce Clause, part of Article 1, Section 8, deals not only with Congress having the power to regulate commerce among the several states, but it's also to control federal commerce. So while I agree that the means are the same, the concerns of states being pitted one against the other is still very much a concern, regardless what the goods were.
I was curious about the current state of interstate commerce litigation with regards to internet, and like more specifically things that have purely digital delivery. I'm thinking about the new law in Utah about age verification for pornography, and have there been other litigation around that kind of, where there's no actual good besides something digital?
Don't know the answer to that.
I don't either.
No, it's good. It's a very good question. There are the notion that a state, for example, can dictate policy that would have an impact outside of its state is one that really is at the forefront right now. The Supreme Court is very comfortable with having a state protect its residents by saying, for health or safety purposes, for example, firewood coming into New York State should not be subject to pests living in it, and that's a health and safety issue. In the national port case, the justices seem to be concerned about, all right, health and safety on one side, but now Prop 12 leaps to the question of policy. So now can California tell Iowa how they should raise their pigs? California says, we're just saying what we think can happen within our borders. But I think rightfully the Supreme Court raises the question of, once you get past health and safety and go into policy, whether it is how you control digital information or privacy, you get into a different area. And it'd be very interesting to see how the Supreme Court comes down, because unspoken during the oral argument were those states that for policy reasons have decided not to allow medical abortion pills. So it's very thin ice for sure, and how the Supreme Court skates along it will be interesting to see. Well, thank you very much for attending tonight. I want to thank our panelists again. Again, thank you, Marilyn, and all of your staff. And
It's been a great audience. Thanks very
privilege
much.
to be here, and get home safe.